Are you going through a divorce and finding it difficult to agree on how to handle your finances? Well, in today's video, we'll be discussing the benefits of a decree nisi financial order. So, if you're looking for clarity and guidance on this important aspect of your divorce proceedings, keep watching. First, let's clarify what a decree nisi actually is. In the context of a divorce in the UK, a decree nisi is a document issued by a court indicating its provisional decision to grant a divorce. It means that the court sees no reason to prevent the couple from divorcing, but the divorce itself has not been finalised. Think of it as the penultimate step in the divorce process, followed by the decree absolute, which marks the end of the marriage. Now you might be wondering, what benefits does a decree nisi financial order offer? Well, let's break it down for you. A financial order comes into play when you and your partner cannot agree on how to divide your assets. It outlines how your assets should be divided according to a court order. But here's the catch. You can only apply for a financial order once the decree nisi has been granted. Why is a decree nisi so crucial? The decree nisi serves as an important stage before the court can issue a final financial order. It establishes a clear foundation for the division of assets, ensuring that both parties have a fair say in the process. While you can technically apply for a financial order after the decree nisi, it's generally recommended to resolve all financial matters and have a financial order or consent order in place before applying for the decree absolute. This way you can prevent future complications or disputes relating to the division of assets. It's about securing your financial future and avoiding any surprises down the road. Timing is key when it comes to applying for a financial order. Ideally, you should initiate the process as soon as possible after filing the divorce petition. Although negotiations about the financial settlement can begin before the decree nisi, it's best to finalise the settlement before the decree absolute is granted. Why is it important to finalise the financial settlement before the decree absolute? Well, the decree absolute can have significant implications for both parties' financial circumstances, especially concerning pensions and inheritance rights. If the financial settlement is not reached before the decree absolute, there's a risk of losing potential claims to the deceased estate or pension benefits. Additionally, until a financial order is approved by the court, even after the decree absolute, the financial claims between spouses remain open. This means that either party could make a claim against the other years later, leading to a potential legal and financial repercussions. So, how do you apply for a financial order? Here's a brief overview of the process. First, you'll need to fill out Form A, which serves as a notice that you're applying for a financial order. You can find this form on the UK government's website. Next, you'll need to submit the application along with the appropriate fee to the court. Once you've filed Form A, you must serve copies of the application to your ex-spouse, notifying them of your request for the financial order. The court will then set a date for your first appointment, which typically occurs 12 to 16 weeks after the application is submitted. This application aims to clarify the dispute and explore the possibility of reaching a resolution without a final hearing. If an agreement cannot be reached at the first appointment, an appointment for final dispute resolution, FDR, will be scheduled. Here a judge will assess the information provided and determine a fair division of assets. Parties often reach a settlement during this process. If no agreement can be reached, a final hearing will be held, during which the judge will make a final decision on how the assets should be divided. Even with the most amicable of divorces, it can still be worthwhile to consult with a solicitor for expert advice on how to proceed. These days, there's many online solicitors that work out cheaper and easier than meeting in person. JustAnswer, for example, only costs £5 for a trial, which could be far less than a traditional in-person appointment. One of my colleagues used their service and saved over £270 on an outstanding parking ticket. I've linked that offer in the description below, and if you use that, you'll also be supporting Money Nerd. So thank you.